This conference will now be recorded.
Okay. Are we good? If you can hear me, every one of you is frozen. There we go.
Yeah, we just started recording the meeting, so
Okay.
we should be on now. So we're starting at, what's my time? 7:01.
Now all I see is MB. I don't see you guys on the screen.
I think the camera went off.
Mike Barada. Oh, that's
Why is the
us. Oh,
camera
you don't
off?
see us. But I touched something. I didn't mean to. I swear.
That's okay. Trying to
There
find
you
you.
are.
There we are.
There you are. All right. We are golden. All right. So I wanted to check, make sure everybody got all the documents in the folder because if you don't, it's going to be difficult to communicate tonight. So you should have a copy of the, well, you probably don't have a copy of the last meeting's minutes. I was late getting those out, but should have a copy of Public Law 180, Public Law 126, and a copy of the New York State tax exemption form. Yes,
Yep. I just
we have all of those. Okay. Okay. All right. So called to order. We called to order. It's whatever you said. And you took attendance. So we have public comment. Is there anybody there to public comment? Are you there as a public, Laura?
No, not really, but
Well, actually, yeah, I'll make a public
Okay.
comment. So Mary Van Paul is now your new commissioner. So I just want to thank you
Okay.
for the time I spent with you while I served as your commissioner. And I guess just because it'll be my only opportunity maybe to speak at the last at the special board meeting. I didn't like that.
Can you hear, guys?
Can you hear this?
Not very well. If she can stand close to the microphone, that'd be great.
Yeah. I wasn't happy with how the special board meeting went with the appeal. And then at our last board meeting, our last regular board meeting, we did change the minutes of the special board meeting minutes. And so and then Rusty later made a statement about how he was disappointed in the process, that we didn't follow the process. And so I just wanted to point that out, right? And so we removed from the minutes that it will not have a negative effect.
On the historic district?
Yeah.
Okay.
And so because it was opinion, right? And so now what's left of that motion, it really doesn't say much, right? And so I think there's a good fighting chance to say, because they made you look at this and review your process and go ahead and do the review once again and put an up or down decision and stuff like that. Maybe you should see or consider if the board should follow, the process and have this be reviewed following a correct process, because how it went was this sort of opinion way, right? And they're supposed to see and judge if you are following the laws with your opinion or your decision.
Yeah.
And not with opinions. So that's why I think, it could be considered to look at because I read out loud the state's opinion about the concrete portion, and what they proved directly contradicted it. And OHP's decision, co-aligned with what the state recommended. So, so the board's decision being an opinion thing and not like based on hearing why you made the decision and like looking at what you looked at to make the decision about the relief and they just sort of said, oh, you're not going to see that from the road, but they didn't really look at the drawings or anything about like the things you had to look at to make that consideration. So I think they should like maybe look at it again.
What type of application was it? So Nate Van Wy mentioned this to me yesterday. And my role is to come in here and do a review of the procedures under the two laws, but I don't have the specific context of the actual action that we're talking about.
Jim, why don't you recap?
Yeah. So here, Laura, I appreciate your candor in this, and your you're coming forward on all this, because Mike sent me the draft minutes, and I noticed in the minutes that it said no ill effect on the historic district, which I would disagree with. So I'm kind of happy to hear that was part of your discussion. I think if you read as a trustee member, Laura, if you read things, their action to overturn our decision would be the same as what we would be required to do, is they should have a written explanation as to why. And that would be the legal side of things. They should issue a statement to us and to the homeowner as to why they overturned the decision. At that point, if their reasoning doesn't match Public Law 126, which recommends that we apply the our guidelines, our national guidelines, and the ones we go by, if they can't use those to justify their decisions, then there's a certain level of challenge. So I'll say that
Jim,
I think, yep.
I'm sorry to interrupt. Can you background him on what you're trying to get a feel for what went down?
What was the application?
So the application came in as a repair, but it wasn't actually a repair. I remember when I first looked at the application, I thought, oh, this is going to be a rubber stamp. It's a repair in kind, which is usually a rubber stamp for us. You're replacing materials with like materials. And then as we looked at the drawings and she came forward with the photograph of what the stone would look like, the stamped concrete would look like, I realized this is a complete replacement and a redesign of the porch, not a repair. So essentially, she is repairing the top half of the porch. So the pillars and the roof would be repaired. A slight change to the angle of the roof, about 3 inches, not a big deal. But the base of the porch, the entire base of the porch, is going to be completely replaced and redesigned. So instead of being made out of concrete pillars or stone pillars or whatever and wood, it's now going to be a solid wall of concrete with concrete on top, completely solid filled in.
Okay, so that would qualify then as under 12611. It was an application for a certificate of appropriateness for alteration, demolition, or new construction affecting.
Essentially.
Okay.
Yeah.
So that's the process we're looking at.
Which is why we had so many back and forths with her about, can you come with us through a different design? Can you, do something other than.
And you folks approved it?
No, we did not.
You did not?
We did not.
Okay. And so the homeowner appealed it?
The homeowner appealed it, went before the board, and the board had a long discussion about how it looked and said they thought it would look fine and approved it. So.
Okay. And they had your full record in front of them?
Yeah.
Right, and I think we identified clearly that stamped concrete wasn't considered an appropriate substitute as a material for use for decking.
The wood porch, right?
Yeah, it would have been appropriate if it had originally been like a stone wall, or if it was a like for like material.
Right.
I think the biggest problem I had with it was it's a complete redesign of material that was.
So I need to clarify. So Mark is your name?
Yes.
Who is Mark again? I didn't hear that in the introductions. Who's?
I'm attorney with Kaufman Gerhardt. The regular village attorney is Nate Van Wy. He had a conflict tonight, so he asked me to review the relevant laws that
Great,
we're talking about tonight and to come in and
great. Okay. Well, thanks, Mark, and welcome. And I'll make more of a comment on the cement, the concrete porch. So our guidelines, which are copies of the national guidelines for historic structures, um, iterates very clearly that for a historic preservation, that the historic elements of the property should be maintained. And the term we always use is replace in kind. So unless there's financial hardship, which in this case there wasn't any claim for that, then a wooden style porch should be replaced with wood to maintain that element and to maintain the historic nature of that property. The homeowner wanted to do concrete. We saw advice from SHPO on that decision. SHPO said absolutely not concrete. We took that in as our data. We used our guidelines, which says if it's wood, you don't replace it with something. You don't replace wood for concrete. And so we stood by the guidelines. We did our due diligence with the property owner. We tried to work with the property owner. Not tried. We did. That was a misstatement. We did work with the property owner through two separate meetings where we suggested, we have an architect right on our commission, we suggested to her alternatives to the concrete porch, told her, financial um, advantages to not doing her method, um, said that it was against the guidelines that we're charged to enforce in the village. And so we worked with her. We left one decision as we didn't make a decision, but to work with her later. And the board said that we shouldn't do that. We should make a decision. So we had a meeting. We finally denied it because she wasn't going to change her scope of work. So the finding of fact in turn, and we had, according to the guidelines and according to what our charge is, we had no options other than to deny her project. Then what transpired is she appealed, and the Board of Trustees held a special meeting to appeal the decision. In the special meeting, they voted once to stand by us, and that, without much discussion, that went down in a vote 2-5, I believe. And then the discussion ensued as to why allow it. And there's a tape of that meeting which you really should look at, because it became opinions of people. With historic modernization, you're allowed to replace a wooden porch, the materials, with similar wood. And that's clearly kind of stated that replacing kind when possible, which means if your porch is made of an exotic old fashioned wood like a old growth yellow pine, you can't get that now. So you could replace that with a similar wood product, but it's wood for wood. And one of the arguments given in the discussion at the Board of Trustees meeting was that I see that a similar product is wood and concrete for a porch, so it's no problem. That's absolutely an opinion that doesn't agree with the guidelines. So that was one of the things that I think that stood out. There was a time in the meeting where I interjected myself in the discussion because they said everybody's giving their opinions on whether they like Trex or whether Trex is slippery or concrete is the same as wood. And that was the main thrust of the discussion. I broke in and said, it's opinion. What do the guidelines say? And I tried to refocus the board on the guidelines that wood for wood or wood and historic up to the state level is allowing Trex now to replace wood because it's wood-like and it has the appearance. And even with that data, they approved the concrete, even though it's against the guidelines, it's against the SHPO's recommendation. So that's where the meeting went. That's my synopsis. Oh, one more thing to throw in is when we made our decision to deny the the certificate of appropriateness in writing. I believe it was 3 pages, and I sent it through our OHPC liaison, who's sitting there. That's Laura. I sent it through her, sent a copy to the mayor, to Nate, saying what our decision was and relating that to the guidelines, to the suggestion, our actions prior to that to try to work with the homeowner to find another solution. And even with that letter of explanation that laid out the letter of the law, um, the Board of Trustees um, appealed that. And I think at a minimum, their appeal would be the same as our decisions on NACOA. They should have it in writing why they overturned. And that in writing needs to really stay close to Public Law 126 and the accepted guidelines for historic preservation in the village. That's a lot, so I'll stop talking now.
No, that's good context. So we did not have a public hearing on this application?
Oh, absolutely not.
No.
We've never had a public hearing
Okay.
for any of the applications we've done.
So it just came up during the meeting. You know, somebody was looking at over the code and said, "Oh, you know, you haven't been having public hearings," and we thought that because you know, we've been this is what we've been doing for years. I would say OHPC follows the procedure better than any committee or board. You
Well, we
know,
try
in
to.
the village with their procedures.
So what I'm sorry, I forgot.
Jim.
Jim.
What Jim described is absolutely correct with respect to the substance of the requirements for the OHPC when reviewing that particular application. The village board, when they received your decision, could have simply rejected it just based on the procedural error that there was not a public hearing.
Right.
Without even going into the merits of the nature of the wood and the replacement, you know, the unequivalent replacement or anything like that. Based on the text of the law, the section on appeals does not require the village board to issue any, it doesn't have any specific requirements for the village board's decision, only that they consider it and determine it.
Okay.
So I think at this point, with respect to this particular application, they did grant it.
Yeah.
Yep.
And under the appeals, it says the board will use the same criteria as this local law, which the base of this local law 126-12 says what we need to do and what's kind of appropriate and not appropriate. I think I was not at the meeting. Doesn't sound like they evaluated it like we evaluated it.
No.
Yeah, they didn't.
They have different criteria, I assume, you know, one
Well,
of which being,
what their role was is to review the record you provided them.
right.
And if anybody was able to articulate how you deviated from the law, you know, that's the application of the law part. Their job on the appeal is to make sure that what you did adhered to the specifics of the law, which they will say they didn't apply it correctly, but also you have the procedural issue as well.
Right.
So even if, so the way to get them to reconsider that appeal is somebody would have to go into Supreme Court and file an Article 78 and
Have them follow their own laws, right?
Yes.
Essentially.
Because what you're saying, what you would be saying is that the village board's determination of this appeal was arbitrary and capricious, and that there was no reasonable basis for that decision. Based on the minutes and the discussion at the village board meeting, yes, that's correct. But if they went in to defend it, they could also point out the fact that the procedure here
Was
not
incorrect.
adhered to.
Right.
So,
Mark, I have one more thing to offer, if you'll allow me. Um, the meeting, when the meeting started, we didn't get right into our proposal. What was thrown out early in the appeal meeting, which I thought was kind of an inappropriate time, but it's legitimate, was the idea of our public hearing. That we didn't do public hearings, and I wrote a letter to Nate saying that we don't make any decision behind closed doors with our certificates applications. That we have a public hearing as part of our meeting. That would be now we'd have the property owners sitting in here or remote, going over their scope of work, talking to them about it, making sure we're sure what they're doing. And so that becomes the open forum for the property owner. And then we make the decision in the room with the property owner. So I asked Nate, if we just put that in the paper, isn't that that was one thing. Isn't that our public hearing? Another thing is, if you want to read the letter of the law, so I'm looking at it on my other screen, it would be under 126-7, power and duties of a historic preservation commission. And if you go down to B, section B, number 4. So this talks about the process, the review, administrative review. And number 4 says, evaluate without public hearing an application for ordinary maintenance and repair of historic resources, properties, landmarks, approved with modifications or deny any such applications. What we were making a decision on was ordinary maintenance, was repairing a porch that's in need of repair. I would consider that ordinary maintenance. I don't think we need a public hearing to do that. The public hearing, if you go to the section on public hearing, that's if there's a main addition being put on a structure, or major windows being torn out and put in on a window. It's not what we usually deal with, which is somebody that wants to repair railings on a porch, wants to, you know, um, put a new base under spindles, want to, shore up their foundation under their house. All of those I would construe as ordinary maintenance and repair to a historic place. It's taking a porch that's there, keeping the porch, just repairing it. So I'm not sure a lot of our actions need the public hearing, is we are challenged in that special meeting on the 25th.
But
And
as
so
you're
that,
saying,
I think
this,
that's a good point of discussion.
yeah, this application itself, although
Mhm,
it came in as a repair, turned out to
mhm.
be a replacement and a new addition, essentially, a redesign.
so
So in
the,
this case, actually, we probably should, in reading this, we probably should have had a public hearing on it on one of the meetings.
this board treated that application as an application for an alteration.
Well, originally it came in as an application for repair.
Right, but
And then-
the level of review
Yes,
that you applied
we
to
treated it like because it was an alteration.
So that's, you're trying to argue this both ways? I mean,
No, I'm
well,
just
no, no.
saying, with this one, we probably should have had a public hearing.
No, I'm saying, but
Because,
if you're gonna say it's not a public hearing, it's just basic maintenance and a public hearing wasn't necessary. The arguments you're making for denying the application are based on the treatment of this particular application as a more significant alteration under this other section of the law. So I think the rule of thumb on this is there's gray areas when I'm sure everything is a gray area.
sometimes,
But when these applications come in, the first thing you need to do is decide what level of review it's going to get and what section of the law is going to, and the procedure is going to apply to it. So
That would be
Mark, I have to tell you that I gave you that information not as a challenge. I'm not challenging that, but I'm just saying I think what I was told, or what we were told, sorry, Phoebe, I know you were there. What we were told in the meeting is that we haven't done this public meeting process, this public hearing process. That was challenged right away, which I wasn't prepared for. I'm a little more prepared now to read through this and say, on the legal side of things, where you make your money is to interpret the words. And I would think I could interpret the words of repairing a porch. She didn't change the dimensions of the porch. She didn't change where the porch was located. It was replacing the porch, the original pillars. The roof was going to be the same with wainscoting. She just wanted to change the materials of the floor of the porch. I would still say that falls under review of maintenance. So anyway, I offer that one just as a data point. The other thing that I have to comment on is when I was told that you had to have a public hearing for a decision, and if this was deemed not a repair but a bigger decision, then prior to that meeting where the board voted on it, technically we should have had a public hearing first so the board could hear all of the arguments and then them have a meeting to vote on it. And so I know that's probably true because the mayor started the meeting by saying, if it's okay with you, the property owner, we will ignore that rule for this meeting, which I thought, wow, that's quite a powerful decision. So I offer that as a data set as well.
Okay. So there's, in this law, there are definitions, and again, I think you could probably argue it either way for the level of work that was going to be done on it. Alteration is any act or process other than demolition or preventative maintenance that changes the exterior appearance of a significant historical or architectural features or the historic context of a designated landmark, including but not limited to exterior changes, additions, new construction, erection, reconstruction. This sounds like what they were doing.
No,
No, they were
complete replacement,
Yeah.
they were replacing.
new
Yeah.
construction.
Essentially new construction.
They're gonna need a floodplain permit. as well.
Okay.
Yeah.
Or removal of the building or structure grade.
Right, removal and then a complete replacement.
So, I mean, really what the board could have done is they could have pointed out the fact that there was no public hearing and sent it back to you.
We tried, they didn't listen.
Yeah, they didn't, they said they don't want to do that.
So they just,
So,
I
nope,
actually
we're just
said
gonna-
it.
Yeah,
So-
I remember you saying that in the meeting.
they just decided it on the merits.
They said, no, we're just going to decide it and get it done with. So, okay.
I'm not sure I have the energy or propensity. I'm a vehicle of the village. I am the OHPC. The five of us are a vehicle of the village, and we did according to what our charge is in the letter of the law. We did what we're supposed to do. If one were to look back at the video and the motion that was made, included in that motion, that everybody nodded their head, that's right, that's okay, was a statement that said, even if it's concrete, it's so far away from the sidewalk that on street view, you couldn't tell anyway. That was part of that motion. So if you really wanted to challenge it, which I don't know if I'm interested in, if you really wanted to challenge it, there's no provision in any guidelines for street view of a historic property that talks about the distance from the street view or defines what the street view is. So they gave an opinion there that you couldn't see it anyway, so let's just let it go. It's like saying you got an illegal door in your house, but let's plant a tree on it. If you can't see it, it's going to be okay. Maybe a bad analogy, but that also was brought up. And I think, if anything, what I would love to have happen, and for our board to gain the respect that it deserves for our original decision, is that the board of trustees be educated on what they did and how they erred in their process to make what ultimately was a decision that demeaned their own commission and took the power away from our commission. Now, anybody that wants a concrete porch in the village, in the historic district, which is against the guidelines, can have it because there's a precedent that that board set. And I don't think they were knowledgeable enough, even though I sent a preliminary email for them to all read 3 or 4 pages of information. I don't think they were knowledgeable, and that's not an insult. They're busy people, that they knew the law that they were supposed to uphold well enough to make the proper decision. So they have to live with it. We will go on following the letter of the law, but I hope if this ever happened again, they would know that the village isn't the buildings, it's the law. The establishment of the village is the written documentation that they are there to maintain as trustees. They're the trustees of the village, and they didn't do a great job on Public Law 126. That's my statement.
Jim, I wouldn't consider this as setting a precedent. This is such an exceptional outlier of all sorts of things. Not only
Let's
the
hope
application,
so. Yeah, let's hope so.
I certainly wouldn't consider it setting a precedent, especially not in the process that we have and in the decisions that we're going to be making going forward.
I'll just make a couple quick, a couple things. I think your argument that the board acted arbitrarily, capriciously on this is excellent. I think two things I would point out is one, based on this law, the composition of this particular board it's not just any 5 people who want to serve.
Right.
They have to have certain qualifications. And the reason for that is because the decisions that come from this board are entitled to a certain degree of deference by the village board. And that should have been, I wasn't at the meeting, I didn't read the minutes. Based on your recount of it, it sounds like that this board did not get the deference that is written into this law, suggested by just the very nature of the fact that, this board, has a certain composition with a certain level of expertise.
Yeah, built in.
To summarily overturn it for the reasons that you indicated they give, I think, was not likely appropriate.
Yeah,
I would agree with that statement.
Do you agree with that statement?
I agree with that.
Yep.
I have looked at the last village board and looked at
I
the
don't,
for a minute.
whoops. Can I,
Well, you have to check in this.
Nadine?
can I ask permission to speak? I don't know where we are. I know I'm supposed to only speak during the public comments, but this is, I have a question. Oh, we still are? Oh, okay. Okay, great. All right, great. Do I have permission to speak? I have a specific question about the meetings, and just for the attorney, the visiting attorney. I'm a former chair of the OHPC, and Jim and I were very deeply involved in the writing of this new law, based on the 2017 preservation law that was handed to us by New York State. And we adapted it to, which we are allowed to do, to our specific needs as a village. One of the things that I'd like clarification, because, you always want the OHPC wants to be doing everything correctly. And this question about public hearing versus regular meetings. And we've always been running our meetings. I'm looking at Chapter 126, Section 5 there, 5B, where it says bylaws. And it says meetings. And it says bylaws shall provide for the time and place of regular meetings. It's not capitalized, and may provide for the calling of special meetings by the chairperson or by written request of at least 2 voting members of the commission. Regular meetings shall be held at least once a month. All regular or special meetings of the commission shall be consistent with the notice provisions of the New York Open Meetings Law and shall be open to the public. And that is how we have for years, and I'm looking at Laura. Laura goes back further with her relationship with the commission even more than I have. That is how we have been holding our meetings in accordance with the New York Open Meetings Law, and shall be open to the public. And we always posted the agenda on the physical door of the building, and we always posted it on the website of the village, and it was on the calendar. So and I know about the section that it talks about public hearings, but I thought that I always thought the way I interpreted the law that a public hearing, and I do remember one time we were in the process of having a public hearing. Laura, do you remember when Mr. Weitzman was going to build the cube on Front Street? And I remember going down and posting on that empty lot a sign 10 days previous, prior to the meeting and all that stuff. I remember going through, he backed out. We did not end up having that public hearing on the construction of that building because the applicant backed out of that one. He decided not to build it. But we had followed all the, all the steps that I thought that should be held. It required a public hearing. So what is your take on the different, I'd like a legal sort of a conversation about the difference between ongoing, I'm concerned that that if we make it too burdensome for people, they're going to go ahead and do work anyway and ignore the application process. If we make it user friendly with by just having public meetings that we post things and keep moving forward and make decisions at the meeting where we look at the certificate of appropriateness, things keep going forward, especially during this time of the year when people are getting their construction projects up and going. Are you suggesting that we always have to have a public hearing for everything we do?
No, what I said earlier was that based on the nature of the application, you may or may not need to have a public hearing, but
So like in the application, for her example was of new construction downtown. In that sort of a case, we would need a public hearing because it's brand spanking new.
and I
But if
think it
it's
might be helpful
administrative,
if I just distinguish between a public meeting with a public comment period and a public hearing. A public meeting is just like we're doing tonight. Everyone's invited. Everybody knows when it is. It's posted. It's posted on the website. It's posted, everywhere. And anybody can come in and speak on any topic. A public hearing is a little different because they usually are done in conjunction with the regular public meeting, or if there's a need for a special meeting, if the scheduling doesn't work out or there's a significant delay. You meet monthly.
We meet
Yes.
monthly, yes.
So the public hearing does a couple things. First, there is a notice of requirement in addition to what you would have for the public meetings, that it be published in the newspaper. And
Right.
that also the individual property owner also has a notice requirement that he or she need to post on their individual property a notice that also indicates when the public hearing is. So if a neighbor comes by and wants to see what's going on, sees, oh, I can come to a public hearing and speak on this particular project. So when you have a public hearing, you usually do it first thing at the meeting. You open the public hearing, you let the public speak, and the public's opinions on a particular project are part of your record.
Right.
Now, based on the project, you might get a lot of opposition, or nobody shows up for the public hearing. But it's part of the record so that, it in and of itself, significant, public opposition to a particular project isn't enough for you to deny a project, but it's a consideration, and you should always take the public comment into account when you're making your decision on a particular application. So the other thing a public hearing does is when you open it, if it turns out based on just discussion from the board or the public that you would like additional information, you then you leave the public hearing open to the next meeting, and you await that additional information. It comes in. The next meeting, you continue the public hearing. The public gets to
Yeah.
see that information and speak
Yeah.
on that.
How do you technically do that and then run your meeting? You just say, we're gonna close this public hearing portion for now, or how do you,
What you do is, we are going to continue this public hearing until the next monthly regular meeting of the board. And somebody makes a motion, and you vote to continue it, and
and then
then,
you go on to
and then
the
you
next
just
things?
start with the agenda.
Okay, okay.
The key to, you don't want to close the public hearing, because
Right.
then that starts your clock for when you need to make a decision by. You have 62 days to make a decision, and you don't get any additional information at that point. So that's why you keep the public hearing open. If for some reason you feel you need more to consider the application. So that,
We would just say we're continuing to the next meeting and
yes.
say the date and vote on it.
Yeah.
Yeah, I would think it'd be very difficult for us, based just on the application, to determine if we need a public hearing or not. Because a lot of times the application doesn't have enough detail for us to make that decision correctly. And the second thing is, when we do have our meeting, our
Open meeting,
open meeting,
whatever, monthly.
the initial discussion, the homeowner presents what their project is. A lot of time we get a lot of additional information or counter information based on what they said in their application.
Okay.
So I would think every meeting or every COA would require a public hearing now.
That's what it says. though.
Yeah,
Yep.
It says it. That's,
We have a
I
meeting.
tried. I read this like 12 times. It says it.
it says it. Yeah, which is
Yeah,
unbelievable.
so when the application comes in collectively as a board, you need to decide what type of application this is. And then go to the law. If turns out you're going to treat it as maintenance, you use that procedure. If it's an alteration or like a rebuild of this porch, I think it's pretty clear it should be held under the
Public hearing, the public hearing.
yeah, I think it's 126.11. So then you follow. This law is very, very well written. I went through it, and it's once you make your decision as to what type of application you are going to treat this as, then the process is laid right out here.
So if we determined that it would be a maintenance, and then we had the applicant come in, and then through our normal process and discussion, we decided, no, this was not just maintenance, then we would
Then
kick
you'd
it
have to
out
kick it in
and
the
make
next
it
month,
into a
right?
public
Then we'd
hearing.
have to
Yes.
say,
So
we gotta have
the
a public
board
hearing on
votes that
this.
we're going to treat this as a material alteration, subject to, section 126.11 of the law, and you set it for a public hearing.
And then we start the time. Because most of what we get in front of the board is maintenance and
Yes.
repair.
I
I'd say
assume it is.
90% of what it is maintenance and repair.
Yeah, and it's important that when you get those applications that do require a public hearing, that you follow that process, because whatever decision you make can be challenged if procedural error with the process. So, once there's decide to schedule for a public hearing, you do your notice requirements it's laid right out here.
Right.
It's it's
Pretty
I
quick.
was, I had to basically bone up on this right before this meeting, and I read through it, and the first thing that came to my mind is this is one of the most clearly written laws I have ever seen. I have seen some laws that.
Thank you, Nadine.
Well, we didn't create the law. The law was recommended to us from New York State, but they gave us the freedom to adapt. Any municipality that's dealing with this can adapt it to fit our needs. And so we did. There were sections that we did adapt, to fit. I am concerned though about this public hearing thing. We're not Albany. We're not Schenectady. We're not building skyscrapers, and we're a little village here. This only works. The work of the Historic Preservation Commission only works when people cooperate and are willing to come forward and do it. We don't want to get into a position where people say, this is just such a hassle, I'm going to go ahead and do it anyway. And then to quote my good friend Jeff Smith on the board here on the commission, then it becomes the wild, wild west, you know.
Yeah.
And the law can help us to avoid that, you know.
So Mark, I'll add on to this, Mark, what you said, I think is significant. I think Laura, who's our liaison, and if that's Terry Van Hall sitting there, a new Board of Trustee member, I think it would behoove us, based on what you said, to have Laura go back to the Board of Trustees and say, we need to firm up local law 126. I mean, if nothing else, this whole episode has pointed out that there's too much wiggle room is the wrong term, but it's pointed out some weaknesses in our public law, and maybe we should really look into rewording it to make it more appropriate to the village and the village needs for historic preservation.
I think along those lines, what you need to do is take a look at each level of review and see if there are some certain types of applications that you receive frequently that may not need that elevated level of review that is in the public hearing,
I
or,
agree.
hearing part of that. The other thing I would suggest with respect to the local law is it would not be a bad idea, based on this last incident, to put in language in the appeals section requiring the village board to provide a written decision on the appeal, citing the reasons for upholding or turning down or disagreeing with this board's decision. So then you have a piece of paper that says, okay, show, that should show you why your reasoning was wrong and theirs is right. Whereas we just have what happened in the open meeting
Right.
in the minutes. So that I think too, if you make it a large enough requirement of the board to write out a decision, they'll be more inclined to uphold your decisions. If you give them that extra, if they can't just say it at the board meeting and then walk away and be done with it, they have to articulate their reasons. I think you will find that you won't have situations like this anymore.
I think that's a very good lesson we all learned in this last episode. So I wholeheartedly agree with you, Mark. I'm so glad you're here.
Can I, Mark, can I ask one more thing of Mark? This is what I think Jim and I learned when we implemented the new law. That calls for a public hearing. That's correct. Is that true, Mark? Whenever you want to make a correction or an addition to any part of the law?
That
Is that
says it
right?
right in 126. It
Yeah.
says it right in 126. Yeah.
Okay. And then that means that the entire law that we have then becomes open for a public hearing, not just the section that we're looking at. Does that make it vulnerable? Does that make the law vulnerable, the good parts of the law?
The way it would work is the board here would send a recommendation over to the village board to amend the law. And the village board then is the one who would either agree to do it or not do it. So the village board then, if they want to amend it, if you wanted to amend just specific sections, you could say section
Yeah.
126-4 will read this now. And the section on appeals will include the following language after the existing section. That you kind of just pick at it where you want to pick at it. The remainder of the law remains the same. So
Okay. Okay.
so you're not.
Good question.
It is a good question. So you're not opening up the entire law to discussion. You are opening up those particular
Okay.
provisions that you want to see changes made to, and that's what the public hearing will be on, the proposed new law, not in in the proposed amendments, not the entire.
Okay,
entire-
all right, thank you.
So I'm gonna kind of chime in with that. I know we've been pretty accommodating as a board, and you all hear regularly from me that we don't get the applications within the 15 days that we're supposed to.
Mhm.
And you regularly hear from me that we don't get a lot of these things called out in 126-13. And I know we're trying to be flexible. I know we're a small village. You know, you hear me just because I'm a rule follower and what I do in my day job. But I think we're now elevating all of this because of this one incident. And we'll be hearing from me more. We don't get stuff within 15 days, or already the procedure is not being followed. If we don't include all the information, photographs, and drawings, this is stuff. If we didn't get that information and we have our regular monthly meeting, we might not even be able to make a determination if it's a repair or maintenance, or if it's an alteration to set a public hearing. Those folks that are sitting here are gonna be like, wait, I have to wait another month or another 2 months,
Mhm.
and I'm not saying that's a bad thing.
I think,
it snowballs.
I think as soon as you get an application, somebody needs to review it to determine if it's complete. If it's not, you give it right back to them and say, we can't do anything with this until this application is complete.
Right. And I
Yeah,
agree
we
with that,
often-
but
we
the
often
kinder,
do that.
gentler OHPC is.
Well, we often do that. I mean, I've made phone calls, Jim's met with people when we get an application to get more detail on a certain application. What exactly are you talking about here? So that when they do come into the meeting, and we always encourage people to come to the meeting, then when we're having the open discussion about the application, we know what we're talking about, and they have brought the extra information that we'll need in cases like that. But I think the main concern is like Nadine and Jeff said, we don't want to stretch out the timeline too much when we're doing our process of dealing with regular maintenance applications. So this is where my concern was. So if to sum up, which I do, so what I'm getting from what you're saying, and correct me if I'm wrong, is that we should review the applications when they come in, determine whether they are a repair, whether it's in-kind repair or not, but a repair versus a major, I don't want to say, a more significant alteration, or change the
And they're
material.
two different paths.
Or-
Maintenance instead of confusing any repairs.
Yeah, so if it's a maintenance side versus alteration, redesign, new construction. And anything on the alteration, redesign, or new construction side would require a public hearing.
And that's sort of what it says in here. I think they refer to it as administrative, the in-kind and the, whatever those words are
The
called,
maintenance
administrative.
request,
And
right.
those do not, it says without public hearing. It's like the rest by
So in other
default
words,
require
the
public hearing.
majority of what we've been doing for
Would
the
be
tax
just
years
that away. Right.
has been fine. The one time we attempted to do a public hearing with a new construction downtown, where Nadine posted posted the bill and everything else didn't happen, but we attempted to have a public hearing about that new construction.
Mhm.
So it looks like we have actually been most of the time applying. It's just in this one instance where it was debatable whether it's a major repair or is it maintenance or is it a major change?
Right. And, I think that's something like that one where I think the first step when you're getting these applications, and if you have to do it in an open meeting, is to say, we've received your application, we are going to treat this as maintenance, or we're going to treat this as an alteration. And then you go from there. The first thing is the application complete. Second thing, what type of application is it? And the third thing is, can we decide it without a public hearing based on the type of application? Or do we schedule it for a public hearing?
Yeah.
So,
and most of the time with major, I keep saying major, I don't want to say major, but with the larger applications like that, with like new construction, elevating a building, elevating a house, they're pretty obvious and there are long-term projects that would.
But they have to go to public hearing before we accept.
Yeah, before
So I
we can
think
make a
that's the
decision.
piece that, like, we think it stops here.
Yeah.
It doesn't stop here until you have the public hearing on the big one.
Yeah.
You know, on your application form, which I know very well because I was participating in the creation of the new COA application. Down at the bottom there, you could put a little category there that you would designate, because you have to make some changes to that form anyway, because the address of the address has changed of the office and things like that. I don't know if the phone number has changed, but you could put it down there at the bottom, what the categories, so that people are alerted right from the get-go. You would check that off.
Is this maintenance and repair, or is it new construction?
Yeah,
new
yeah.
construction?
And mirror these
But
reports,
will
right?
we
with
leave it up to
defense.
the applicant then to determine that?
Well.
No,
the
no. There's an
applicant-
Yeah, and then we can agree or disagree.
there's an administrative checkbox at the bottom of the form. I think it's on the front page.
Yep. That's where you approve or disapprove, or, yeah, and that's where the chairman has to sign if you make a decision.
Yeah, so that could
Yeah.
be
It's a neat meeting. Yep. Yep.
Yeah.
So if we got
So
our
noted.
applications within the 15 days,
Yes.
then we could quickly look, we could quickly look at the applications and determine first if they're complete, and second of all, if they're not a repair or maintenance, then we would alert the property owner and the village that we would have a public hearing at our next regular meeting, right? So there's a potential time that they would need to post the sign 10 days in advance. We'd have to advertise it as public hearing, so we could accommodate, but it comes back to that 15 days and a complete application and, trying to
But the clock
Herb the
does, if you
cats.
didn't give me everything, the clock doesn't start,
Right.
right?
Right.
So
Clock
the
doesn't
15
start
days
until
doesn't,
the application is complete.
till the application is complete.
And I just wanted to go back to, you made me think of something when you talked about somebody who's lifting.
Yes, we have an elevation.
No.
Right now.
So I'll give you just a scenario there. So if you went through that process for that particular application without holding the public hearing,
Mhm.
and the neighbor sees it, says, I hate this. I want to overturn this approval. If they can show that they did not have an opportunity to be heard on that project for the lack of a public hearing, then
Oh, that's-
there's issues.
Yep.
Especially too if the homeowner has already expended money too.
Oh, yeah.
So procedure is important, especially in any type of land use type.
One more question about procedure. In our public meetings, we do have public comments at the beginning and the end of each meeting. And we do, when the recording thing is working right, we do record the meetings, and they're supposed to get posted on the village website. But the minutes always get posted after the meeting on the village website for anybody to have access to. Our regular meetings are basically the same format as public hearings.
Well, except in a public hearing, you don't vote.
Right.
There's no.
Yes.
It's not put in the newspaper, so that,
Right.
going back to his scenario, that neighbor may not know that this is even going on.
Right. There's more public.
Well, I think that there has been some discussion about the newspaper thing. I've been to a few preservation meetings where, people are not reading the newspapers. That isn't like the be all and end all of village communication now. Websites, which our meetings do get posted on, I think could be argued, and Mark, you could help me with this, could be argued as the equivalent of posting in the newspaper, except that the language of the law may say newspaper.
The language
does.
does
It does.
currently, yeah.
Yeah, and that may be something you want to change. It's also cheaper for the village.
I don't want to kill a.
But in the interim,
That's
we have to
open meetings
follow
law for
the law.
public hearings. So until the state changes that, and you're absolutely right about the newspapers.
But the point is that neighbor then can't come back and say, we didn't follow the process. It's in the
Right.
newspaper. The fact that they
Yeah,
didn't
we
read
did
it.
it, we did it.
Right, it's not your job to make them read the newspaper.
Right.
It's your job to
To post.
have it available in a timely fashion.
Right. So regarding that, the minute to the meeting that we're supposed to approve next on the agenda include the approval of the elevation for Kim Trahan for 275 Front Street. And this is something that probably should have had a public hearing.
Now,
So,
has the clock started because we haven't approved it
no, we have approved it. We approved it
so the
with
clock has
last
started?
meeting,
technically?
the last 30, yeah.
Not if we didn't follow process.
So what I'm wondering is, can we now have a public hearing?
Let me see.
Well, this, I'm gonna defer this, Laura, Terry. I'm gonna defer this to the Board of Trustees who were very cavalier about ignoring the public hearing when it came to their last decision. Um, and they didn't handle it like a public meeting. I'm going to send it back to them saying that we just made a decision to approve Kim Trahan's house elevation. That's a pretty major thing. It's beyond repair. It should have a public hearing to that. And I would charge the Board of Trustees to host that public hearing. That we told them our decision on that. Now we need a public hearing before that can become an official document. I know it's backward, but we may have to vote a second time after public hearing. But I think is a lesson it's you know it's a responsibility of upholding the law for the Board of Trustees to send it back to them so they know the gravity of ignoring certain aspects of the law. So I would suggest that I think that's a good claim, Phoebe, that yeah, Kim Trahan's is beyond the repair that we talked
Yeah,
about. Send it back to the Board of Trustees and say, what do you want us to do about it?
I don't
Make a
want the
suggestion.
homeowner in this instance to have a problem later when she's in the middle of elevation that,
Right.
the landlord next door decides it's gonna flood their place or something, or, no.
But sending it back to the Board of Trustees for what do you want us to do about it? We're now abdicating responsibility.
Yeah, I think we should have the public hearing.
Yeah, I think you should call the public.
We should be
hearing
calling a public hearing
to
on this.
Just even go through the exercise of how you're gonna have one, and then you can hear the evidence again
Right.
after it.
And in the interim, we call Kim and say, stop.
And then,
Pause.
Guess what, Kim?
so what about,
She's done any alterations to the property, it's just a plan.
Right, she hasn't done anything yet. It's all still in the.
No,
public
but I'm
first.
just saying, like,
Gearing up
this,
for
but
She's
construction.
gearing up
this
for
is a
it,
big
so-
deal. This is not a little deal.
She's looking somewhere around the 15th to get started.
Yeah, so we need to,
So, looks like May 6th.
You can also call a special meeting, just as long as you're following the timelines for,
the public hearing.
posting the public hearing. So you could speed up that much in, not holding monthly.
So you don't have to wait for another meeting of this. You
Yeah,
could do it.
we could
then,
just-
too.
72 hours is the notice you need to give for a
That's
special
all?
meeting. Yeah, well, it
Yeah,
depends on when
for
you're-
special.
No, but that's a minimum, okay.
Right,
But
But
if
if we
post a placard
had-
or have a placard posted by code, on their property, right? Because nobody here is gonna do that. Code will enter the,
Right.
go on the property and post that. And.
I think in 126 it says that the property owner.
It does say that, yeah. I
Oh,
thought
the
that was,
property
yeah,
owner
it says
needs
it.
to post
I now am an
okay.
expert in
there
this
has to
law.
be something posted on the property itself.
But
Yes.
we will make sure it goes into the newspaper.
Who would be in
Yeah,
charge?
we would
from
have- that's right,
DPW.
right.
So we could, if we went and talked to the DPW tomorrow to do a public hearing, we could do a public hearing on Tuesday, the 16th? In 10 days?
So,
We have to be there, right?
there might be something you
But
might
there
have
might
to
be something
figure
going
out
on.
with, when the newspaper is published.
Yeah,
And they need to let,
usually they have
that
to
goes
have them
out
in by
once
Tuesday.
a week, right?
Right.
Actually, we picked both the Courier and the Press and Sun to be our papers of record. And then.
And this,
That comes out
It's
more
daily.
often.
yeah, this
Yeah.
my comment here is this is probably outside of our discussion here is probably outside of public comment now. We're still in the public comment period, so we probably should get to our agenda, and then when we talk about new business, establish all of the specifics about a public hearing on Kim Trahan's property.
Future.
Yeah, because a lot of this discussion really would fall under our discussion
New
of
new business. Yeah.
appeal process and the public law, which we have in the agenda.
Yep.
Um,
So Mark,
Yes.
anything else?
yeah,
You can stay for the rest of the meeting, but anything that would be appropriate for a public hearing part of our meeting, do you want to offer? Or
Um,
Laura or Terry or anybody?
No, only that, if you ever have questions on specifics, I put my email on the sheet. I'm happy
Thank
to
you.
look at it and see, advise one way or the other, try to apply the statute to the particular application you're looking at. Yeah, we're here to help you with that as well.
Okay,
If,
good. Thank you.
Excellent.
there's
Excellent.
questionable things.
I agree.
We'd rather not be questionable. So,
Great. Anybody else? Mark, thank you very much. I mean, it's very helpful. Everything you've gone through. All right, should we progress?
Did,
all right.
did you want me to stay?
Oh,
Or?
you can
You're
stay.
welcome.
You're welcome to stay if you want.
But if you want to run for your life, you can too.
Yeah, you can also.
No. If you have a life outside of
You
this.
have a life, right? You're...
All right.
I'll stay for
So I
So the next,
apologize for getting the March 7th minutes out as late. I thought I'd sent them and I checked the emails. Maybe I did. Did you, anybody get them ahead of tonight?
yes, I got them.
But yeah, today, not, yeah, we got 'em.
Yeah, I was really late on that, so I apologize. There are some edits that I'll suggest, Phoebe, if you have it up on your computer.
I do.
And most of them are misspellings. So under public comment, Kim Trahan is spelled wrong. It's Trahan.
Oh, there's an L in there for some reason.
Yeah.
And I missed that too. I didn't-
Schaefer should, under approval of minutes, Schaefer should probably be capitalized.
Yes, please.
Approval of minutes. Oh, yep.
Which
Gotcha.
Yeah, Patricia.
Miss Shaver.
Under COA application, owner Cindy Bobnick. I think Cindy does not have an E at the end of her name.
Oh, okay.
I think it's an I.
India.
And then you're going to have to do this several times. So in that vote, it says Overheiser abstained. We have to give a reason, according to public law, why I abstained. And that's, you just have to add remote, that I was remote. So I'm
Okay.
not in physical presence according to
Do
the
we need to
law
put
of
it
the meeting.
Because at the top of the meeting notes, it says Jim Overriser, chair, remote.
Yeah, but you're supposed to say why you abstain. That's the letter of the law. So let's just stick to it, not get in more trouble.
Not a problem.
So anytime I had a vote, you're going to write remote. So page
I'm good with
2,
that.
under the motion, another I abstained remote. I will be back to the next meeting. Elevation landscaping owner Kim Trahan is TRA, not TRE.
Sorry, where was that? Where's the
Elevation
second one?
landscaping.
Elevation landscape.
Under by elevation landscape, you just spelled Kim's last name wrong.
EHAN.
TRAHN. Yep.
Did I have it
Scroll
spelled
down to the
incorrectly?
bottom of that page and same mistake. Right in the last paragraph, Trahan should be TRA.
TRAHAN. TRAHAN. Thank you.
Good. Next one, the motion. There's 2 abstains in there.
Yep.
Overheiser
Those.
abstained. Yep. Okay. 2 more remotes
Yep.
under the next. 2 more remotes under the next. I am
Yep.
so sorry for that. I really
That's okay.
like the weather down here, but I'm anxious to get back because I know it's a pain in the rear end for everybody. And I think that's all I found.
Okay. No other misspellings.
Yeah, there's actually in the historic inventory at the bottom, you actually capitalize an H-I. The I is capitalized and it shouldn't be, but other than that.
Historic inventory. Where am I?
Jim, give us where? I can't find it either.
Oh, right in the last, I'm sorry, I got to scroll down again, sorry. It's second to last paragraph. It starts with Overheiser requested. The second to last word in that, it's historic and it should have a lowercase I.
So you want the lowercase
Oh.
I, okay.
Oh, I have a lowercase I here.
Oh, you have a cap
Okay.
But
right now. Oh,
yeah.
that's funny. Gosh.
it could be. Oh, I
All right.
see. Yeah.
And Jeff, you
Okay.
had something, capital I.
40 Lake Street, COA. says I was a nay, but there was 4 ayes. I was an aye on that.
40 Lake Street, the sign?
Yep, the COA.
Yeah, the sign.
Second,
Do-do-do-do.
this is 4 ayes.
Why do I have unanimously approved? Because I know you didn't vote for
No,
it.
I
It's just-
did,
yeah,
I
you-
did approve the sign.
You approved the
It was
sign, but
right, the awning above, I did not.
you didn't like the awning. Yeah, where's your nay?
In the
Opposed.
parens, at the bottom,
The parens
bullet
after
with the
all ayes,
COA.
right.
Yes, I see.
And the only other comment based on our open discussion earlier was for the 28 Lake Street application. Was that a replacement of an existing awning? Photos we had, I don't remember seeing an
That's
awning
what she says.
on that building at all. There's not one now until they put it up.
You know, that becomes a technical question because there was an awning on that building,
Once upon a-
on both of them. I mean, that single building is owned by Mark, right? Or Matt,
Yeah.
excuse me, Matt Romano. They had awnings on those buildings, and they're returning the one to the Convection Connection side, and they replaced the one that we already approved on the barbershop side.
But the
So-
language currently says replace existing,
Right.
Yeah, it does.
so strike existing.
Because
So it's not a repair, a maintenance.
That's a good
so it's
point.
a
Yep.
awning, thus public
It's
hearing.
returning, right? It's returning to the original awning, I guess. I don't know. That's a good catch.
Are we comfortable with that as a replacement in kind?
because there was an awning
Or is that
there.
an alteration? Oh, mamma mia.
Oh, yeah. See, this is.
Yeah, you know where I'm going. I just
Yeah, no,
Make
but,
sure
well,
we're
let's establish it now so we
crossing
understand
our
what we're
T's,
doing.
dotting our I's.
Yep.
So the previous one was cloth, it was at Susquehanna Screen Printers.
Right.
This one is not.
This one is not.
Yes,
This
right.
is a new
But
vinyl.
it's,
And it's not, I saw them, they're behind the building right now. They haven't been at
Mhm.
both of them, actually. And it's not like a tarp sheet vinyl sort of thing. It's solid panels of more of a, is it vinyl? It's not even vinyl. It's more like a, I don't know, fiberglass, some sort of plastic. But it's
Yeah,
a
it's
solid,
some sort of plastic. Mick Knapp sent me pictures.
so is this subject
actually
to
a
the
little
new and improved or the old and listened to process?
yeah, because it is a major materials change.
Yep.
Yeah.
We talked about that, if you recall.
Yes, I
You know,
recall we talked about that at the meeting, even though the frame may be the same and the size is very similar to what was there. We're looking at
This is
it's
an
not even
alteration.
as close as like a sheet vinyl, which would look like canvas.
Right.
It's when I saw the materials behind the building, they're like a panel.
Right, they're not using the old crank out awning, cloth awning that was
Right.
there before,
Right.
the crank out hardware,
Right.
that's gone and they're
That's
putting
gone. It's a
something-
solid piece,
I-
and it's not even.
I just wanna make sure we're comfortable with, replace or
Right.
repair or whatever language apply with the law.
So is this subject to public hearing or not?
I think it might be.
I'm afraid it is,
Yeah, because
because it's different enough.
I would say no if it was
Something there.
the more canvas style
Yeah.
vinyl, because
because
that would
it's
be a
this
lot
hard, so-
closer to what was originally there. It would be like using composite materials
Which
instead
is
of
really
wood
interesting, 'cause that's
materials.
not what is described in our verbiage.
No.
You saw the thing.
And then I physically saw it as I happened to be walking
Right.
behind the building, and I'm like, that's not vinyl. I thought it was like a vinyl tarp sort of material. Maybe a little better than the plastic ones you get, but
Awning will be aluminum frame,
yeah.
matching awning will be style, so we don't really, interior illumination. Sheet vinyl, we did say sheet vinyl
Yeah.
tarp,
Sheet vinyl
and if
tarp.
it's not sheet vinyl tarp,
It's a solid panel.
Well, this is in two things then, it's not described correctly. Any chance that what you saw is not what they're doing?
No,
It's somebody else's
No.
awning that's just hanging out there.
it's their awning. It's a solid, it's not a sheet vinyl, it's solid panels. Yeah.
Well, then we approve something that's not what they're
Not
doing.
what they're doing. We may have to call them back in, 2 people. Great.
Is that something else we put to the board?
Well, I don't know what the
Village
village
board?
board can do about it.
Oh, we can't give them
We-
everything, because then we just, like, I'm not coming anymore.
We're not,
No.
I'm just asking, I wanna make
No,
sure
I'm
it's
with you,
correct,
I'm with you.
and I don't wanna cause any heartache to anybody.
No, but I'm thinking between the elevation, which I know we definitely would need a public hearing for, and then this, where it's such a major materials change, it's not even going
I
from,
mean, it's new construction, yeah.
well, it's kind of. I mean, the frame is the awning is the same, but it's not a sheet vinyl, it's not a canvas.
I think the
It's
word
not a
alteration
canvas-like
applies. I
material.
think it's an alteration.
It's
That's what I was
it's
just
an
gonna-
alteration,
yeah,
thank you, much better
yeah.
verbiage. Where it's such a major
Alteration, okay.
Major
Yeah, I mean,
alteration.
it's, and the fact that we approve language that's not what's happening, I think is also important. So that one, how do you undo?
Well, we contact the homeowner and we call them back in and say, hi, we're gonna have to have a public hearing on this because it's a major alteration of materials.
And I think the definition of alteration needs to be edited as well. So it says any act or process other than demolition or preventative maintenance. But in a
No,
previous section, it talks about repair,
Mhm.
as well.
yeah,
So we might wanna, maybe we can alter our definition of alteration, say
There's a
other
definition
than
of alteration.
repair. And maybe it's.
So here's my precaution to all this discussion. And granted, we're supposed to be approving minutes now, not discussing.
that's
This
true.
would be old business, right? But I
Yes.
will precaution you that the window for challenging this may have gone by because we had lengthy discussion back in August 2021 about the same awning over the barber shop, and we went through that with the barber pole, and we approved all that, had a similar discussion, and this came forward as the same style awning. And in the minutes, we indicated that. At August 12th meeting, we approved it, right? So that it's something we should bring up right now. We just need to approve the minutes before we move on to that. We can address that in old business, so to speak. All right.
Yeah.
Okay.
So what was the language change is the only thing we need to know here. A language change that we should put in there. Sheet vinyl tarp with confection. What was the wording that people didn't like?
It's different material.
It's a different material. We approved for sheet vinyl. Yes. So,
Okay.
which is a tarp.
Okay.
This is like a hard thing.
Yeah, sheet vinyl
Okay.
tarp
Composite panels.
as opposed to a composite panel.
There you go.
Okay.
Solid.
All right. So the language, all right, the language we don't want to change that language then because our argument would be based on what we approved and what they're doing are
Right.
two different things. Okay. All right.
Okay.
So at this point, if there are no other edits to the minutes from the March 7th meeting, any more edits? Okay. So I need a motion
A
to
motion we
approve
approve
the,
minutes.
Second.
yep.
You.
Okay. Second. All in favor?
Aye.
I.
I'm
All
gonna
right.
have to
And I
abstain.
abstain because I'm remote. Okay.
Okay.
All right.
And but we're still a quorum.
But we
three
still
of
have
us.
three, right?
Right. Okay. All right. So we need to get the non-draft version of that, Phoebe, up as soon as we can, just to be good there. We don't have any applications. I was made aware that a couple might be coming in and nothing ever came to fruition, so there's nothing to discuss there. Next thing, the informal discussion on past approved or potential. I've been in discussion with Alicia Saratani and Les Wagner about 97 Front Street. In our last meeting, what came up is that 97 Front Street, there was a sale on it that fell through, and it's absolutely a model historic home. And our concern was who the owner was to communicate with the owner. So I was on top of that. And Alicia and I have been talking. And when I get back on Monday, probably by Wednesday, I'm going to meet with Alicia and Les Wagner, who own the property. And they've hired a contractor, and they're very interested in maintaining the historic elements and historic nature of that property, which is really good news. So it behooves us to meet with them and to have discussions about historic tax credits, um, historic property tax deferment, to talk about all of the help that we can give them and to make sure they understand the guidelines. Their contractor is John Barton. John, is that right? He was the one. He's the one that was going to do Matt's windows, right? Did I say the name right? It's Barton, not Bolton, right?
No idea.
John, who's right there next to, he has the house right behind the the Baptist church.
Oh, Bolton.
Bolton,
Yes.
there it is. John Bolton, there it is. I never remember. Okay, so he's their contractor on that. So I'm gonna schedule a meeting with the three of them, and I will let all of you know that I'm gonna be sitting down having coffee with them, and kind of talking about their ideas, and sharing with them everything I can about the benefits of keeping things historic and working closely with us. So that'll be forthcoming. Does anybody else know about future projects, anything happening in the village?
Yes, Terry?
I believe Les Wagner has also bought the house, Mike Wolf's house, two down from.
I didn't hear you very well, Terry. Sorry.
Sorry.
I
Talk to
Can you
this. Don't
talk to the
him,
microphone?
Talk to the mic.
Since he can't see you.
I would assume Les Wagner will be coming in also for, I think it's 408 Front Street. It's Mike Wold's house. He bought that last week, 2 weeks ago also.
Okay.
So I
I,
would just be
I
looking for
can,
him. So he's gonna be
yeah, I
invited.
can. All right, that's good. I'll ask him about it when I meet or when we meet with him. So
I think it's 408. It's that one in
you
the
said
corner, the cupola.
you said
Yeah.
409 front 409.
Is it on your side? Or is it on
408. I think.
408.
Grocery Street?
It's too far down on that side.
Yeah, 8 would be our side. We're round.
All right, that's good to
And
know.
and Jim, there's one more on the front page of today's Courier. Um, the building at 247 Main, there's a photograph of it because the land bank is seeking requests for proposals for redevelopment of it. So it's on the front
Yeah.
page. There it is.
Yep.
There.
Yep. That's good. It means SHPO turned down the demolition. That's what that
Yep.
means.
Yeah.
Yep. So that's good news. I know they hit a brick wall. We approved the demolition, but they got to the SHPO level and SHPO said no. So that's good to know. All right, I will look for that article and contact them, say we'll work with you.
And
Anything else?
for everybody's knowledge, my office owns drawings of that building that we
Yes.
have been compensated for, so that would behoove any developer of the property.
247?
Oh, that's good to know. Yeah, that's good to know. I'm writing a note. Okay, good. Anything else? Wow, this is good. No? So moving on is discussion. We just had, thanks to Mark here, we've had a great discussion about the public law, and I don't know if there's more that I want to add right now. Um, what I planned on doing, not knowing we were going to get into the lengthy discussion, was to go through kind of some of the highlighted things that I want to reaware all of us about the public law. And maybe I will still do that. If we can go to the local law 126, that document, go right to the top. I read through it word for word several times, and I highlighted some things I thought I want to make us all aware of as we go forward. Everybody set with the document? So I'm going past page 1 to page 2, Historic Preservation Commission 126-2C. 126-2C. And I tell you this because this may come up. I don't know if Laura has any more information, but if you read the minutes from that special meeting, um, outgoing trustee Morton put on the table to fire me because of, um, because of, I thought he should recuse himself from any vote because of past action. So he started that action with the board, whether that's going to continue or not. But the provision is there that it's the board of trustees that can do that, just to let you know. And it can be with or without cause. So we'll see what happens. Continuing to, it would be page 3. So provision E, 1, 2, and 3.
Wait a minute.
Yep.
Jim,
Yep.
It says with cause. I remember looking at that. Voting member,
Subject to approval of the Board of Trustees with or without cause. It says right
where,
at the end of the provision.
wait a minute.
This is 126-2C, with or
That's only
without cause.
official members, though. It says
Yeah.
for the voting member of the commission must be removed by the
Subject to approval after a public hearing.
Board of Trustees after a
Oh,
public hearing for a cause.
true, true,
So it's ex officio members that can be removed with or without cause.
Oh,
true. I didn't catch that. It's
Yeah.
good.
That'll
So
catch
maybe
you.
I'm safe for a while. Okay.
it's
All right. That's good.
Well, it has to be, it has to be for cause.
Yeah, that could be disappointing
We were,
news. I don't know.
I remember that because we specifically chose that language. I remember that.
Okay. All right. I remember now too. Under E, section E, I highlighted 1, 2, and 3. You know, the letter of the law is we're supposed to have licensed realtors, historians, architects, and so on. But within all that, if you read through that, if you can't satisfy that, the mayor can still accept people to the board. We're lucky to have an architect, and I mean it is what it is. There's nothing they can say, well, we're invalid in appeal. They can't say we're invalid because it addresses that by appointing a person who's qualified in section E. If it cannot be filled, the person so qualified, the mayor and the board of trustees can appoint others. So I highlighted that. Under G, under vacancies, so expiration of term shall be appointed by the mayor. That just tells us to take the pressure off the board of trustees. I went after Cookie, I went after Ira to find candidates for that, but both of your names were sent to the board of trustees for a final approval on that. So it wasn't just us, just to let you know that is part of the process. We found you as viable commission members and then sent your names up to the board who approved them. Compensation. I love this one on I. So you're on page 4, at the top of page 4. No compensation, but the secretary can receive compensation. So that's how we can pay Phoebe to do all the amazing things she does. And I had a discussion with one of the board of trustee members that's not in the room not too long ago, and I said that you have to consider that your salary compared to mine, you make $5,000 more a year than I do. So yeah, we pass this. Now the next is training and attendance requirements. So I want to re-emphasize, I'm writing the report, the certified local government report that goes to the state. Very important to keep our status that this report be submitted. And in that report, I have to identify the training that any one of us has gone through. If you haven't done that for me yet, please send me some stuff. The other thing I would encourage, if we're supposed to do 4 hours, if you haven't hit your 4 hours, find YouTube videos that address this. There are a lot of the webinars that have happened that are now YouTube videos. Go and watch some of these videos to give yourself a little exposure there, and take that video, the URL of that video, and say, I watched this video, and send that off to me. That's certainly eligible for training. I'm not trying to like go around the rules, but there's not a ton of training out there. And if one happens to come along that we can't participate in because of our own schedules, it may be difficult to get those 4 hours in. All right. So let's be attentive to that, and make sure you send me soon. Some of you already have, of what training sessions you've been part of over the last years you've been commissioner. Okay. All right. So that's it on that. No. Okay, 126.4, section A. And the last sentence here is what my remote. If any commission member abstains from voting based on a conflict of interest or otherwise, the member must also state his or her reasons or grounds for doing so on the record. So that's why I had Phoebe add remote, 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 because I have to abstain from all the votes that way. And I know we've had a couple of, I abstained from the vote. I don't want to vote there, but we have to give a reason. And so that's just an awareness thing for us there. And next one is 126.5B. I want to point out the last sentence there. And Mark, this is a good one for you. You've probably read this. The last statement here about bylaws for the meetings, and we already kind of went here. The last statement, all regular or special meetings of the commission shall be consistent with the notice provisions of New York State open meetings and shall be open to the public. And I thought if that statement implies that if it's open to the public, that it's actually a public hearing, then maybe that satisfies the public hearing side of things. But we already had that discussion. If you,
Just for the record, I had that line also highlighted, so.
all right, that's good. Great minds, Mark. That's good. All
Before
right.
we run too far ahead, one thing about training, I mean, technically, I did about an hour tonight on the law and interpreting the law.
Oh, that's nice.
So I know it has to be approved by the mayor, but I'd be happy, or one of us would be happy to come once a year and do an hour in service on just how application of the law and procedures. That could be-
Actually, that might not
That's
be
cool.
bad,
Would be good anyhow, but it wouldn't hurt to get the credit too.
especially if we have new members.
Yeah, like me.
It's nice to get, just
All right,
like
thank you.
when Mike set out the review of the open meeting laws. A
Yeah,
lot of new
right.
members are not aware of all the nuances with open
Right.
meetings.
So to that point, the New York Open Meetings Law, when it says, notice provisions of the New York Open Meetings Law, does that mean we're supposed to be putting something in the paper? Okay. Is there anything we're not doing there? I guess would be the question that we're messing
That's
up.
posting on the website.
And the
You know,
door.
You have your regular, the third Thursday
Yep.
every
Yeah.
month, so.
First Thursday.
First, right? Yeah.
Oh, I'm sorry, first Thursday.
It's been a long day.
It has, but no, your regular meetings are properly noticed.
Okay.
Okay.
So that's not the same.
Can we,
So,
I was gonna say, can we say that we did an hour of training tonight, and
There you go.
just like I watched a YouTube video,
We got an hour
I
of
signed my
training
name.
on local law.
I think you would want to have put something in front of the mayor,
To say this,
say that,
is this okay?
I spoke, we did an hour on the law and asked that he approve that as an hour of training.
In-kind training for OHPC.
Yeah. Okay. Ordinarily, if we did it in advance, I would have handouts
Right.
and,
Okay.
have an actual presentation. It's just more of a.
That's okay.
personally, I think that's a great idea, Mark. And so I'm gonna make sure Laura and Terry hear that. That would be great. That would be a great thing to do to make sure we're all kind of up to date. So take that back as a board agenda and, bring up the issue that if you want to spend the money to have Mark or Nate or anybody give a workshop for us on the local law and the ramifications. I think that would be great, especially in light of recent events.
And you said free too, I heard it, right?
You did
Yeah.
say.
Did I say free?
I did.
Aren't you on retainer?
No,
There you go. There you go. That's good.
Actually, you could say to the board, that would be a good idea for all their
Yeah,
committees.
yeah.
At the
just
beginning
as a
of the year,
refresher for
as a
everybody,
refresher.
I know
You wouldn't have to do an
procedures.
hour, but a little 20-minute, half-hour refresher on rules and regulations and what you're supposed to be doing.
No,
Doesn't
but
hurt.
for something like this, if it's hard to find training,
Yeah.
and I mean, you can do it in conjunction with a meeting too, just to get everybody. It might be an easy way to hit an hour or two of training.
I've our requirements. All right.
That's all great. The next one I'm going to mention, I've already been to. It's on the bottom of page 8, section E, districts and designated landmarks. This defines the historic district in Owego.
So what number is this?
This is E, so it'd be 126.9E right at the bottom of 8, and it bleeds over into page 9. There's a whole long description, and um, I've already talked to the commission about this in other meetings, that there are, I think, holes in this. And Nadine cautioned me when I was going through this, that she and Nate, when we were creating this public law, went through this, and the errors that are in here um, do not corroborate with the maps that are online or the actual records of the historic registry in the town. So this is something that should be um, talked about, discussed, analyzed, and then once corrections and once the final wording is made, should be taken to the Board of Trustees and should become a public hearing to change the wording of this. So I caution that. And Nadine, I know that she's here, so Nadine said that we went over that, but as I read through this, looking at the maps that we post online, which everybody sees as official, and the descriptions here, there are some errors in what it says here. So I would like to make that on a future agenda to really put a concerted effort into modifying the language here.
The one thing that I would alert you to is that the reason that particular paragraph was transferred from the previous old law into the new law, and Nate was pretty clear with me that even though we were aware that there was some discrepancy with the maps, that description is what the federal government recognizes the description as. So we cannot, as a village, change that. You'd have to go up a couple different steps to do some sort of a correction. It's not as simple. I do not believe it's as simple as just correct it. It's not like adding and the trustees have to give a reason. It's a different level of approval there. So.
And so it's an interesting question. So, we should all talk about this in a meeting where we can sit down and look at the maps and look at this, because going through, and I went through on our local maps and the National Registry, the list of our buildings that are on the National Registry, and the maps don't corroborate or the language from this. So I would think that the National Registry is the federal government level. And if that's what they say is on our registry, it should be in the language here. That's all.
It's complicated because there's the local district and the state thing and then the national.
Yeah.
I just think that you're going to need to talk to people at all the 3 different levels first, and then get all that cleared up with them, approved, because we were designated a historic district, and that was the language that they had. That's why
Right.
that language has been carried forth from. So it's more
Yeah.
complicated than that. But I think going to the board is like the last thing that you do after all that's cleared up.
Yeah.
Amending the
Okay.
local law is the final step in that process. Once you get every other agency on board with the correct description.
So we'd need to amend it on the federal level. Okay.
Is this to get the map to be real?
Yeah, to
I
get the
mean, why don't
map,
we annotate the map?
to get the map to match up with what,
Yeah, so the
Our
map is not
district
coming from the
actually
federal
is.
government.
No, it's coming from us.
Right,
but there's been,
There's 2 separate districts that aren't combined.
right,
right,
in,
right.
on the map, which probably should be.
Maps.
So maybe kill the map.
Like, kill the map and just,
Say, see this.
We always run by the language that's in the law and not the maps that are drawn.
Yeah.
Like, that's the language of the law.
right. But I know even at the time, there were errors on it because I've been going through Dad's old stuff, and there's notes from like 84 and 85 when this law was written of that, no, this is missing these 3 pieces on John Street. There's a few houses missing that should be included, and there's some poles here and there. and details on why specific holes like the auto zone was left out.
Yeah, or a couple of those houses on Ross Street.
The Ross Street houses should be included.
So it's an agenda item for the future.
It should be
Moving on.
included.
Yes. Yes. Yep. I think that's all I wanted to point out for tonight. I mean, there's several things that I highlighted, but they're more for my awareness than the group. So I think the last thing I'm going to talk about, if you go to the 180, the 180 law, which chapter 180 is on taxation. And you don't have to go very far on this. Right on the opening page, it talks about preservation law, the Village of Owego, real property tax exemption. And this is more an awareness than anything, is realizing that there is a possibility for owners to apply for an exemption for property tax increase. If they were to do some major work on a property, which could equate to a reassessment of the property and an increase in property tax, there's an exemption that they can apply for. And the table is, if you read down under 180-24, the table for that exemption is there. And if you read the letter of that law, the homeowner has to apply for this exemption. And it's pretty clear on the exemption. And I sent you the form that I'm going to now keep in my file to send to people that apply. They have to fill out a form and send that in, and then New York State informs the tax collectors in the village and town that that property is exempt from taxes for the first 5 years after the work, and then it's prorated after that for the next 10 years until it's
So Jim,
full
I
actuation.
read this and got all excited and called Peter, who's an accountant. For
Yeah.
those of you who don't. And his reading of it was that if you've been levied with increased taxes because you've been reassessed, then you can
Right.
get relief. So
Right.
my assessment hasn't gone up in like 115 years. So if my assessment hasn't gone up, I can't use this to get a discount. I can only
Right.
apply, right? So
Yeah,
that is
yeah.
a different thing than just because we did, $5 million worth of work on the house, we can get an exemption.
No, that's
Right.
the tax credit.
That's the
Yeah.
tax credits, yeah, but so that almost the reason I'm saying that is because it sounded as if we could, as homeowners, go ask for this, but only if they try to levy
No,
more tax.
This was put in because we had several people on Page Street who refused to repair their houses. Because I remember when this went in, thank you. But they refused to repair their houses because they were afraid of the assessment going up and their taxes going up. And they said, okay, you can repair your house, you can get 5 years of no tax under this exemption if you repair it properly.
And if the assessment is raised,
Right.
the assessment has to be raised.
And the assessment is raised
Yeah,
on your
yeah,
house because you repaired it.
Because I thought that I was over-assessed and learned a lot about this after talking to the assessor and going through all kinds of records. And okay, I wanted to make that clear because I had
I think that's great information, Cookie. I appreciate that information. And so often when we do work on properties, then you're often reassessed tax-wise. So if the village doesn't do that, that's great.
yeah,
But
it's
now we have something that we can offer
have-
homeowners.
Oh, yeah. According to the village records, don't go fix anything, anybody. It
Yeah.
hasn't been since 1975 or something. Like, that's not true.
A lot of
but-
them.
And I keep filing whatever I'm supposed to be filing, so. Don't fix
All right.
it.
There you go. That's good
Peter said,
information.
"You want me to fix it?" I'm like, no, don't help me.
No, don't help me.
That's good. Well, that's all I have for those. I mean, I have my own highlights that I don't have to bring up here, but it's been a long night. In terms of under old business, in terms of the vinyl sheeting, I will follow through on that. I'll follow through with that. We have two. One is a business owner, the other is the property owner. Matt is the property owner. The business owner would be Ron and Michelle Pelton. I'll send a message to both of them saying that the product that we're seeing on the property does not agree with what we approved, and we'll see what happens from that point forward.
Yeah.
And
All
are
right.
there other properties that are in this in-between stage where we've said yes to something that should have gone to public hearing that we should look and see? We know the elevation, right? But are there other things that are like that that we should go back in time?
Yeah, it's a good question. So I have a list of all the COAs that we've addressed and kind of a general description of what they did. So I'll go back and take a look at that list and give us a list in our May meeting.
I don't really remember anything other major this last year when you're thinking back.
Well, you did a big addition there.
Oh, yeah.
Yeah.
Oh,
It's so done though. I mean, it's done. It's finished.
He's
There's,
sleeping
you don't have to go back in time.
Sleeping
It's
on
something
that.
it's finished, but
That's
if there's
true.
things that are not yet implemented that we've said yes to in this like in between stage.
Yeah, also the question is how far do we go back?
Yeah. Well, if it's done, you don't go back. You're not going to go to his house
There's
and
a-
say, let's have a public hearing at your house.
There's a building in
Right.
the
And so our big decision, and this will come your office too, Mark, is once we talk about this, that are we required to go back? I mean, you can go back to 2000. When was local law instituted? Nadine, 2019,
The new one is
18 or 19. Do we have to go back that far and
No.
go through public hearing? You know,
There's 30 days to appeal the decision.
yeah.
So,
Ah.
and I think too, you don't really want, I think this is more of a, from this point forward, like,
Yeah, we don't want to
I
open a
would
can of
not-
worms.
I would not
No.
disturb.
So since we haven't said yes to Kim's
Well, we
elevation,
did say yes to
No, we
Kim's
didn't.
elevation.
so then we don't go back there either.
No,
When did
we-
you say yes?
We did say
When-
yes at the very last
A
meeting.
month ago, 30 days.
It was a month ago, the last meeting. We said yes to the elevation.
That one, I believe, that has all kinds of.
Such a
federal-
big deal. It's
Federal money and everything.
It does.
I think my recommendation would be to let that one.
Well, Mark, what I'm going to do is to send. We have your email address now. Do I send things to you and not to Nate now? Is that what I understand?
No, I'm just here
No,
for
you're
Nate,
just here for today.
tonight.
Okay.
Nate's
All right.
still the guy. If you can't reach him, or he'll probably give it to me anyway, or whatever. One of us is fine, but.
Okay.
No, so Nate.
Well, I have Nate on my red phone, my hotline. So I will send our decision in the description of what we went through with Kim. It's all in our minutes. But I'll send him all of that information and ask him that question. Do we need a hearing?
I would be interested to know what his approach would be on that.
Yeah, should we do
All
a
right.
post-approval public hearing for this or not?
Yeah.
That seems to be the only one
Because that's
could
the
be.
only one really.
Okay.
I think the
Yeah.
zoning thing, just, we need to contact the owner.
Well, I think
Okay.
you're not gonna be able to, the approval would have to be revoked.
Yeah, and then we'd have to reapprove it after geez.
Yes, because
And it's already been 30 days.
the whole purpose of the public hearing is so that people can come and give their opinions to you on whether you should approve or not approve the project. So if it's an ex post facto public hearing.
Nothing
that
much you can
is
do,
already
yeah.
approved.
Yeah.
Okay.
I don't know what Nate would say, but I don't know that that's really.
So we're gonna say going forward,
Yeah, that's cool.
from here on out.
I think to do the public hearing, you would have to revoke that.
Yeah.
Yeah, okay.
So we'd have to make it to be more of a mess than worth it.
And I'm sure that project's pretty well known to everybody,
Oh, yeah. Well, I would hope so, but
at least the neighbors.
it's obvious if
It's
you're
a good
walking by.
point. You don't know what's
It's-
happening next door.
Why did you take down all the trees? What's going on?
The other side's around them, so that's a little hard.
Yeah.
Who knows what.
But does the tenant have the same rights?
No,
No, live property owner.
only the property owner. All right.
We good with all that?
Yep.
What a great meeting. I mean, this has been very instructional. So I love it. So I don't have any reports other than I'm working on the CLG for the Board of Trustees, so they can send that in, and my annual report, which is submitted to them, but it's going to be one and the same this year. So that's my only report. My chair report, the same. Public comments. Any more public comments before we sign off?
Don't say anything.
Mike Wold's house is actually 412, not 408. Sorry about that.
Oh, thank you. I'll make that a notion. 412, not 408. Where was that?
That was 412 Front Street?
7.
Correct.
Yep, found it.
Okay. And you said a different name. I got West
It
down
used to
here.
be Wald. Wald is the prior owner.
Okay.
He was a commissioner for a while.
Les Wagner bought it. I don't even know who these people are, but I remember
Oh,
things.
that's Wagner's nice. Yeah,
Okay.
Wagner.
Oh, that I know that.
All
Yeah,
right.
but I don't know. If he walked in, I wouldn't know who he is.
Tall guy.
If he walked in with a sign, then I could.
Yeah. Okay, well, Laura, appreciate you being here. Terry, thank you for being here. Look forward to you becoming a Board of Trustee member. And Mark, thanks for your insight and your expertise. It was extremely helpful.
Thank you.
Um, Great. I need a motion to adjourn at
I motion to adjourn.
8:51. Second?
8:51.
That's not like
Yep.
I'll second that.
Okay. Okay.
All right, all in favor?
Right.
Aye, one abstain, remote. All right, folks, thank you very much, and we'll see you around town next Tuesday.
Thanks for the warning. We're all going to
Thanks,
get.
Nancy.
All right, yeah, very good, very good. All right, thanks a lot, everybody.
Take care.
I'm turning off
All right.
the meeting.